the opening of our academic year in a sense. I am very happy and honored to have Felix Ronkes Agerbeek with us today to give a lecture about Europe's courts as allies. And my name is Thomas Beukers. I work as a part-time professor at this faculty. I'll be your chair today. I think for many of you, Felix does not need an introduction. I'm going to do it anyway. Felix has been working at the legal service of the European Commission for quite some time now. He's a very experienced lawyer. He has been the lead negotiator of the European Commission in the EU accession to the European Convention on Human Rights file for several years. He's been in Barnier's team in the Brexit negotiations. He's represented the Commission before the Court of Justice in more than 100 cases. So he's a very experienced lawyer, but I would say he's also a brilliant negotiator, and a negotiator by training, because he's been very intensively involved, not only in the practice of law before the courts, but also in the practice of law in politics in negotiations. He's also the host of a very popular podcast, Europa Felix, which I understood also some of our students are already familiar with. So that's a good sign. Today, Felix will be talking about Europe's courts as allies, about the relationship between Luxembourg and Strasbourg, about challenges, tensions, cooperation in times of polarization. After the lecture, there will be time for Q&As. After the Q&As, there will be time for drinks next door, so I invite you to stay. And without further ado, I would like to give Felix the floor.
Thank you very much, Thomas, for that very kind and generous introduction. Thank you also very much for inviting me here in the first place, you and Christina. It's a real pleasure to be here with you and a real privilege. So the idea today is that we join each other in conversation about Europe's courts and the adjudication of fundamental rights in an age of polarization. Now, that is a very grand theme, and I say that with a smile because actually my own day-to-day is anything but grand. Most of my time is spent on the ordinary work of the law, preparing notes and briefings, reviewing documents to make sure that they don't contain any glaring legal mistakes, and of course also standing before the judges in Luxembourg to argue about the meaning of like a single subparagraph in a piece of EU legislation. In other words, it's the routine work of preventing or putting out legal fires. But here's the thing, like none of that work is only routine. Even in the smallest corners of our legal system, choices are being made. Choices about fairness, choices about how we live together, choices about what justice really means in practice. Now, that has always been true, but I think today, when our democratic institutions feel under strain, I think we sense it more acutely. So timeless questions about law, politics, and society, they resurface with greater urgency. And it's for that reason that I'm glad we can discuss them here together. Before I begin, I have to add my usual disclaimer that nothing I say today necessarily reflects the official position of the Commission, and that the views I am about to express are mine and mine alone. My main point, my thesis, if you wish, is this. Europe's highest courts are sometimes portrayed as rivals, but in reality, they are above all allies in the adjudication of fundamental rights. And that is especially clear when we look at the Court of Justice and the European Court of Human Rights. Much has been written about the differences in how these two courts approach human rights adjudications. And yes, it is worth studying those differences, but the overall trend in fundamental rights protection under EU law and under the Convention is one of complementarity, not conflict. The case law of the two European courts shows reinforcement, not rivalry. And if we zoom out to include national constitutional courts as well, I would argue that the same is true there too. Because the deepest tensions in our system do not lie between courts, they lie between courts and politics. I've been pressing that argument for quite some time, and once it sounded a little contrarian. But today, I think it's hard to miss. The examples are everywhere. For now, I'll just stick to two: migration and climate. I could have picked others, and we can absolutely talk about those later if you like. But I think these two offer a good starting point for discussion. Let's start with migration. Migration is one of those fields where national law, EU law, and the Convention overlap very clearly. It's also an area where the politics are particularly heated. Consider a recent case from Ireland, SA and RJ. This case came to the Court of Justice from the High Court in Dublin as a Frankovich claim for damages. It was a pilot case, and so it's meant to guide similar claims that are still pending before the Irish courts. Now, SA and RJ are two asylum seekers who had arrived in Ireland, but for 2 weeks, they were not given accommodation. They slept outside in wet and freezing weather, and they often went without food and were exposed to violence. The Irish authorities, they did not deny the breach of EU law. They accepted that this violated the EU directive on reception conditions, and with it, the respect of human dignity. But they argued that they should not have to pay damages. The failure, they said, was excusable. The reception system had collapsed under the pressure of a sudden influx of people, many fleeing the war in Ukraine, and housing capacity was temporarily exhausted. Now, the Court of Justice rejected that defense. It recalled that applicants for international protection must never be left without the minimum conditions of subsistence. A saturated reception system is no excuse. Even in times of strain, the most fundamental needs like food, shelter, and safety, they must still be met. Now, this case was argued on the basis of the Charter, but its close connection to the Convention, and above all, the prohibition of inhuman or degrading treatment, is evident. And that is what makes SA and RJ such an interesting example. It shows how EU law does more than echo the Convention. It reinforces it, not just by protecting the same fundamental rights, but by making them enforceable with the full weight of EU law, primacy, direct effect, and liability in damages. SA and RJ shows us one direction of travel, EU law strengthening Convention rights. But the traffic runs both ways. Convention law can also reinforce EU law. And the recent judgment of the European Court of Human Rights in HT versus Germany and Greece shows how. That case was about the return of an asylum seeker from Germany to Greece, the country where he had first applied for protection. Now, some of you will remember the MSS judgment from 2011. And there, the Strasbourg court found that sending an applicant back to Greece under the Dublin system violated Article 3 of the Convention, because the asylum process and reception conditions in Greece suffered from systemic deficiencies. Around that same time, the Court of Justice in NS reached the same conclusion in a similar case. It held that mutual trust between member states could not go so far as to require blind trust in the face of systemic deficiencies. Yet the MSS judgment from Strasbourg, it went a step further. The Strasbourg court said that there must be a rigorous and individual assessment in every case. And that raised a hard question, because how does that square with the EU's principle of mutual trust? So in opinion 213, the Court of Justice expressed serious concern that the convention might be applied in a way that undermines that principle, the principle of mutual trust. And much of the talk about conflict or divergence between the two European courts dates from that time. But look at where we are now. 15 years later, both courts have built a rich case law on mutual trust, and each has come to understand the other's concerns. You can see that in the case of Jabo from the Court of Justice, in Real Madrid, or on the side of the European Court of Human Rights, in the case of Bivaloru and Moldovan, and in many other cases. Now, the emphasis differ, but the direction is clear. Not conflict, but convergence. Not rivalry, but reinforcement. And HT versus Germany and Greece is an example of that as well. Now, HT was a Syrian asylum seeker. He had first applied for protection in Greece and later made his way to Germany. But there, he was stopped at the border. He asked for asylum, but his request was never registered. Instead, within hours, he was put on a plane back to Athens under a bilateral administrative arrangement between Germany and Greece. And this was effectively bypassing the Dublin system, so the EU legal framework. Now, conditions in Greece have improved since MSS, but at the time of HT, they were still not adequate under EU law. So under the Dublin system, national authorities, they could not simply assume that Greece was a safe destination. And in fact, HT's own treatment in Greece confirmed it in practice. And that's why the Strasbourg court held that Germany's summary return under the bilateral administrative arrangement violated the convention. Now, I think that there are two things that are worth noting about this judgment. First, the Strasbourg court has made clear that removals of asylum seekers, whether to a non-EU country or to another member state, it does require careful scrutiny under Article 3. That obligation does not change simply because the transfer takes place within the EU. A bit similar like in Jabo. But in the HT judgment, the court did note that intra-EU transfers occur within a distinct legal and institutional framework. And while that didn't alter the outcome in this case, it suggests that this context matters, maybe not to lower the standard, but perhaps to inform how the sending state satisfies it. And in that sense, and I say this cautiously because this was not the core question in this case, but I think in that sense, it suggests an openness to taking the principle of mutual trust into account, also in the field of migration. That's the first point. On the second point, I think it's interesting to note that this judgment, it really leans on EU law, on the Reception Conditions Directive, on the Dublin III regulation, on case law from Luxembourg. And what the judgment ultimately does is to reinforce that body of EU law, making sure its safeguards cannot be sidestepped. And in this, the judgment fits in a wider trend. In SH versus Malta, for example, the Strasbourg court indirectly reinforced the safeguards set out in the Asylum Procedures Directive. Now, of course, the role of courts in migration cases is not only to set limits. Much more often, in fact, they find no violation of rights at all, and they leave authorities broad discretion. But those rulings, they attract less attention. And even in cases where courts do draw a line, I should say, like SA and RJ, and also in the case of HT, the courts emphasize that states retain a wide leeway in this field, in this area. In any event, here, the two European courts, they are pulling in the same direction. And I would say that's a good thing. The political response, however, that has been another story. So, for example, earlier this year, 9 European leaders issued a joint letter openly criticizing the European Court of Human Rights for, in their words, protecting the wrong people by stretching the convention too far in expulsion cases of migrants with a criminal conviction. Now, others have done a much deeper job of analyzing this letter than I can hope to do today, but I will simply note 3 points. First, the tone and emphasis of the letter are not without consequence. It frames outsiders as the source of danger, and it casts law and individual rights as the obstacle that keeps us from being protected against them. And I want to be very clear, I am not suggesting that this was deliberate, and I recognize that the leaders grappling with these issues, they face real pressures, and I believe they want the best for their citizens. But whatever the intent of the letter, the effect is familiar. It fuels fear of the foreigner, and it works to strip away limits on government power. Second, the letter is all assertion and no facts. On history, it gets the record wrong. The convention was created at a time when Europe saw huge migration flows. On the present, it offers no verifiable data at all, not about migration and not about the case law it is ostensibly criticizing. And that matters because the Strasbourg court is highly deferential in expulsion cases. In practice, states win almost all of them. Third, and finally, although the letter speaks of democratic values and the rule of law, it is, in fact, an attempt to bring political power to bear on the court. 9 leaders proclaiming in one voice through an open letter that the court should bend to the will of the majority they claim to represent. Look, whatever one's views on migration, we should see this for what it is. Political pressure on judicial independence, plain and simple. The letter was aimed at the European Court of Human Rights, but it is hard not to hear in it a message to the Court of Justice as well. And that brings me to the larger point. The real tension is not between Europe's courts. It is between political power and an independent judiciary. A similar tension is also visible in the field of climate change. Now, this is an area where I know that many of you are the experts, and Christina most of all. So I won't take you on a tour of the case law. Okay, Urgenda, Neubauer, Klimasenioren, the ICJ advisory opinion. I assume you know them inside out. But what I can offer instead are a few broad reflections to see if they resonate. Climate litigation, I think, is a great example of how judges, national, European, and international, draw on each other's reasoning. It shows, in practice, what former president of the European Court of Human Rights, Shifra O'Leary, once called a complex web of jurisprudential cross-fertilization. That doesn't mean courts everywhere will land on the same outcome. Each case comes with its own circumstances and litigants. Each court sits in a different legal and institutional framework, and judges may bring different readings of the law to the table. But none of them has to operate in a vacuum. And this cross-fertilization also works in more subtle ways, in cases that may not grab the headlines, but are still significant. Take, for example, two judgments, recent judgments, from the EFTA court. The first is Norwegian Air Shuttle from August 2024. That case gave us the very first reference at EEA level to klimaseniorinnen. And having cited that judgment, the EFTA court then proceeded with a strict interpretation of a company's obligations under the ETS directive. So even if a company goes bankrupt, it still has to surrender its emission allowances. The second example is Greenpeace Nordic from May this year. And the EFTA court there held that environmental impact assessments for new oil and gas extraction projects must also cover the emissions from burning that oil and gas. In other words, downstream climate impacts have to be part of the assessment. So as I said earlier, even in the smallest corners of our legal system, important choices are being made. And it's true, the European Court of Justice has not yet had a climate case. An attempt to bring one directly was thrown out on admissibility grounds. But make no mistake, those cases are coming, and most of them, I think, will take the obvious route through national courts. Because to meet their obligations under the convention, national courts will have to open their doors to climate litigation, including when EU law is in play. And if the Court of Justice's case law on the Aarhus Convention is any indication, it will likely nudge them to do just that, so that climate cases can then reach Luxembourg by way of the preliminary reference procedure. And when they do, when these cases come, the court will have to assess them in the light of the Charter, which, after all, must offer at least as much protection as the Convention. And so here you can see that this web of interaction between national courts, the ICJ, the European Court of Human Rights, the Court of Justice, is on full display in the field of climate change. However, as Christina also pointed out in a recent article on climate constitutionalism, even as all of this unfolds, the fault lines between the judiciary and political institutions are deepening. When governments lose these cases, the reaction is often immediate and predictable. This can't be right. The judges have overstepped. They've embraced the green agenda. They've gone against the will of the people. And yes, that line gets plenty of traction in the media and public debate. But stop and think for a second. Judges in Europe are not, to borrow Kastansin's phrase, radicals in robes. The notion that many of Europe's highest courts, and even the International Court of Justice, have all been taken over by climate activists just doesn't stack up. It doesn't wash. So what's actually going on here? Well, judges follow the facts. They follow the law. And they take seriously what governments themselves have recognized about climate change, including in their international commitments. There is nothing radical about that. In fact, when you look closely at the judgments celebrated as great victories for the climate movement, what stands out is often not how bold they are, but how cautious, how carefully calibrated. And moreover, courts, they don't rush in as if they alone can solve climate change. They struggle very earnestly with the limits of their role. And Klimaseniorinnen shows that. You can see it both in the way the court looked at standing and in how it judged the merits, scrupulously balancing, on the one hand, the limits of what it can do as a judicial institution, and on the other, the responsibility that comes with being the guarantor of convention rights. Now, whether you agree with the outcome or not, there is nothing anti-democratic about that. Independent courts doing their work diligently, conscientiously, in good faith, that is democracy. Climate litigation shows us once again that Europe's courts are not working against each other, they're working together. The real challenge comes from the political pushback their rulings spark in today's polarized public square. Polarization is hardly a new phenomenon, but these days it seems relentless. We witness it, we hear about it all the time in politics, in the media, in everyday life. Now, I am not a political scientist or a sociologist. There are others who can explain its roots and dynamics far better than I can, but I do think it matters profoundly for fundamental rights adjudication. And that brings me to some concluding thoughts. We often talk about polarization as a political or cultural phenomenon, but its effects reach deep into our legal systems too. In a polarized debate, there is less room for nuance, less patience for fact-finding, and very little tolerance for loss. Even the most carefully reasoned judgment risks being misconstrued as a shot fired in a partisan tug of war, a marker of loyalty, a proxy for identity. And in that environment, when a judgment goes against you or against the side you identify with, it doesn't just feel like a legal setback. It feels like suffering a stinging defeat in a broader societal battle. And that's when the pressure builds. That's when we see attempts to capture the judiciary, to bend it toward one side of that battle. It's when politicians start to resist, sometimes even resent, the judiciary's greatest assets in a democracy, its authority and its independence. And if this sounds abstract, look across the Atlantic, because it's playing out in real time in the United States. There, we are starting to see just how far things can slide when political loyalty begins to weigh more heavily than the rule of law. It's a cautionary tale of what we stand to lose when things go off course. But it's also a powerful example of how much we stand to gain when diligent judges stay the course. Because many lower federal courts are doing exactly that, often under intense pressure. Now, I have to say that I admire these judges a lot for their commitment, their steadfast commitments to their craft. A former US Supreme Court Justice, David Souter, he passed away earlier this year, he once described what he called every judge's common obligations. And he put it like this: suspicion of easy cases, skepticism about clear-edged categories, modesty in the face of precedent, candor in playing one worthy principle against another, and the nerve to do it in concrete circumstances on an open page. If much of that sounds like the opposite of polarized discourse, well, then that's exactly the point. Some see courts as defenders of human rights and democratic values. And of course, they can be. They often are. But if courts are to be a bastion of anything, let it be this: a bastion of facts, a bastion of reason, and a bastion of calm and careful deliberation. The very things so often missing from polarized politics. It is through this shared commitments to facts, to reason and deliberation that independent courts stand together in an age of polarization. Where does that leave the rest of us? Students and academics like you, civil servants like me, academics and civil servants like Thomas. What does this mean for us? Now, I know this can all feel overwhelming, like the ground is shifting beneath us, and like troubling things are happening everywhere all at once. So how do we deal with that? And first of all, I do not have a grand answer, but I do have two thoughts. So first, when I'm not giving lofty speeches like this one, I focus on the work that's in front of me, however mundane it may seem, because I've seen how even small choices and actions bear the imprint of what a person stands for. That's the first. But the second is that I try to carry myself a little more like the judges I admire. So I try to look at the facts. I try to question easy labels. I try to think things through case by case, and also to remember that there's always the next case. Now, I know that may sound underwhelming. It may not feel like it meets the moment, but if enough of us do it everywhere, all at once, I believe it will make a difference. Thank you.